Good afternoon, class. We are going to continue our discussion on the offense of murder. The last class and for the lecture video I uploaded earlier, we discussed what homicide is, what lawful and unlawful homicide means. Then we started our discussion on murder, and we already talked about the provisions of section 316 of the criminal code, and we talked about the requirement of murder. Now we're going to start our discussion today on peculiar cases, which means that what if there is a contributory factor? Because we have said that the law of causation says that the act or omission of the accused must have caused the death of the deceased, as of the victim. So what if it's not only basically the act of the accused that led to the death of the deceased? What if there are external factors that also contributed? Who becomes liable for murder? Now, the first scenario we're going to look at is contributory cases. The most important thing you need to note is that if death can be attributed to the injury inflicted, to what the accused has done to the deceased, it will be liable. So it means that the accused will be liable if the deceased subsequently dies, if the wound inflicted is also a contributory cause of his death, regardless of whether there was any external help from anywhere. So far, what the accused did death can also be traced to what the accused did. He will also be liable. So if the deceased aggravated his own wound after he has been inflicted injury, after the accused inflicted injury on him, the accused will still be liable, because death could still be traceable to what he did to the disease. For example, if after injuring the deceased, the deceased refused to, they told him, after giving him treatment, they warned him not to take alcohol, and he took alcohol and eventually died. The court will still hold the accused will still be liable for murder, because if he had not injured the accused, even if he had taken alcohol, nothing would have happened to him. So the injury inflicted on the disease is also a contributory factor to his death, and so he will still be liable. So the principle is this principle is what we refer to as the principle of causation, which says that an event is caused by the act proximate to it, and in the absence of which the event will not have happened. So if you have not injured him, for example, and even if he takes alcohol does not ordinarily kill, but because of the injury inflicted on him, he was warned not to take alcohol, he eventually took alcohol and he died, you will be liable. So you can see the case of Uyo and Attorney General of Bendel State, where the court held that the prosecution must not only prove that the actions of the accused might have caused, no, he must prove that the actions of the accused actually caused the death of the deceased. Now, that's for contributory cases. Let's look at acceleration of death. Acceleration of death simply means that though the accused carried out some acts which inflicted injury on the accused or the deceased, what if an external factor, somebody else or something else happens which accelerated the death earlier than what the actions of the accused could have done? Who will be liable? So a person who accelerates the death of another, suffering under another cause, is liable for the death of that person. So that's what section 311 of the criminal code says. So if X, for example, administers poison to Y, who becomes ill and who maybe would have died in 2 hours, but before the 2 hours, X cuts off his head. Now X and not Z cuts off his head. Z and not X will be responsible for causing Y's death, because though he had administered poison, the poison had not resulted into what he wanted before an external factor came and Kukuma carried out another action which led to his death. So the question will be, is the actions of X also contributing, or is only solely the death of the accused of the disease is actually solely based on just the accelerated factor? If it is based on solely on the accelerated factor, then the initial actions of the accused will not be criminally liable. It will be the accelerated perpetrator, the person that actually perpetrated the last event which led to his death, will be liable. But if what the person that actually did something to the accused and the deceased after the accused has done it, both of them will be liable. So once the cause of death cannot be traceable to the injury inflicted by the accused, he won't be liable. That's what you can see the case of Uyo and Attorney General of Bendel State. So as long as death cannot be traceable to what the accused did initially, then the perpetrator of the event after would be liable for murder. But if what the accused did and what the next person did both contributed to the death, then both of them will be liable. Now let's look at existing condition of the deceased. So it means that if the deceased has a medical existing condition which renders him more susceptible to mortal injury than any ordinary human, if you actually inflict any injury on him and he dies, which normally would not have led to the death of an ordinary human that doesn't have any medical condition, you will still be liable, because if you are not inflicted him with injury, he wouldn't have died. So the rule is you take your victim as you find him. So you take your victim as you find him. In R and A ward, the accused arrived home and was annoyed. That was what happened. The wife had existing medical condition, of which his action actually contributed to her death faster than, which wouldn't have led to the death of any normal human being that doesn't have a medical condition. The court held that he was still liable for murder. So the fact that there's an existing medical condition does not relieve the accused of criminal liability for murder, as long as what you did actually caused the death of the deceased. So you won't be allowed to say that it's because she was sick before. So you have to take your victim as you find that person. So medical condition, regardless of whatever of the disease, does not relieve you of any criminal liability. Now the fourth one is victim's neglect of treatment. So if you cause injury to the victim and he refused medical treatment and he eventually dies out of that injury, you will not be allowed to say as a defense that if she had taken treatment, she wouldn't have died. The rule is you will be liable, because if you have not injured her or him, the disease will not need medical treatment, which also happened in the case of R and Blau, where the victim was a Jehovah's Witness, and according to her religion, she said she wasn't taking blood transfusion, and you injured and she eventually died because she refused to take blood transfusion. The court held that he was still liable, and that you won't be allowed to raise as a defense that it was a disease that diffused medical treatment. Now the fifth condition we're going to look at is an intervening event or act of the third party. So where, for example, you injured the deceased, and then an intervening event comes to hasten the death of the accused, what happens? It depends on if, like I said, it depends on if death can still be traceable to what you did. If it can still be traceable, then you'll be liable. So if, for example, the question is where there is an intervening event, the injuries that you inflicted, was this also a major cause of death or just that intervening event? If it's just that intervening event, then the accused will not be liable. But if it's contributory, just the intervening event and what you did, you will still be liable. So if A, for example, injures B and leaves him on the roadside and he dies of infection, you will be liable, because if you are not injured him, you wouldn't have died of infection. The wound would not have been infected. But if you injure him and you put him on the road, and then there was an earthquake, or there was a thunderstorm, and then he was struck by lightning, then in that situation the thunderstorm or earthquake was what killed him, not the injury, and then you will not be liable. So also, if A stabs B and shortly after C stabs B, and death can be traceable to the cumulative effect of what both A and B did, both of them will be liable. So it depends on what the intervening event or act of the third party is, and whether what you did was not a reason for his death. If death can still be traceable to what you did, you will still be liable. Now the sixth one is intervening medical treatment. If you injure the disease and he even decides to take medical treatment and he dies of that medical treatment, the issue will be, will you be liable? The question is if the medical treatment that was given was reasonably proper and was applied in good faith, you will be liable, because if you had not injured him, he would not need to undergo medical treatment. That's the rule. But if that's according to section 313 of the criminal code, but if the medical treatment that was given was not reasonably proper and was not applied in good faith, despite the fact that he was being treated for the injury you inflicted upon him, you will not be liable, which was what happened in the case of R and Jordan. He actually inflicted injury on the deceased. The deceased went through treatment, but the treatment that was given was not proper in that circumstance, was not reasonably proper, and was not given in good faith. So it was the court found out that he died of that medical treatment, which was not proper, rather than the injury you inflicted, and then the accused will not be liable. So the treatment given the disease must be reasonably and proper, and must be given in good faith. If not, you will be liable. If it was given in good faith and it was reasonable and proper and the person still died, you as the accused will be liable. Now, what is the penalty for murder? According to section 319 of the criminal code, it is death penalty. So, and usually what we do in Nigeria is death by hanging. So once they sentence somebody to death, it is death by hanging. So that's the punishment for murder if the person is guilty. The burden of proof is on the prosecution to prove that the accused actually killed the deceased. That's, you can see the case of Onyo and the state. So the burden of proof is on the prosecution to prove beyond reasonable doubt, not on the accused. Because as much as possible, the accused is presumed innocent until the prosecution can prove him guilty. What are the defenses that we have? The defenses to the offense of murder: self-defense, that's one. Provocation, you can prove that you were provoked. Self-defense is an absolute defense, so the accused will be exonerated. If it's provocation, it only reduces the offense of murder to manslaughter. So if the defense of provocation avails the accused, it will reduce the offense from murder to manslaughter. So you will still be punished, but it's not an absolute defense. Then also, insanity is an absolute defense. If the defense avails the accused and he proves that he was insane, he didn't know what he was doing at that time, it will avail him. It will be absolute defense. Now, the defense of accident is also absolute. So it's also always a defense to murder. So it's an absolute defense. Now, witchcraft is not a defense to murder. In the case of Amnuki and the state, it was a murder case. The accused raised the defense of witchcraft, and the court held that the belief in witchcraft that leads to commission of crime is no defense, and that killing because of a delusion that he was bewitched by a doctor cannot be justified. We have come to our discussion on murder. So you can download this lecture video and read the note I've sent earlier. Then we'll continue our discussion with the online class. Please stay safe and be good. Bye.